Good evening, this is John Milburn. This is Laws 12067, Environmental Law. This is week 11. We are initially continuing our discussion in relation to criminal law. In relation to criminal law, we discussed last week the process of deciding whether it's a summary matter or an indictable matter. And in general terms, a summary matter is a matter that's dealt with entirely in the magistrate's court. An indictable matter is a matter that is dealt with through the committal stage in the magistrate's court and then on to the higher courts for the presentation of an indictment. So there's some reading in your commentary about that, and have a look at the specific legislation. For example, the Environmental Protection Act deals with the issue in terms of if an offence is more than 2 years maximum penalty, it's indictable. If it's less, it's summary offence. Similar processes in the Vegetation Management Act, etc. So most of the litigation that involves criminal law will be dealt with in the state courts rather than the federal court. And in the commentary, you've seen that if it is a matter that is dealt with in the state courts, consider not only any defences that might be available in the legislation itself, such as 319 of the Environmental Protection Act, but also the Criminal Code. And I'm talking in the Queensland context now. So Section 24, honest and reasonable mistake of fact. Section 25, emergency. 319 of the EPA is the general environmental duty. And due diligence, 493 of the Environmental Protection Act. So understand some of those basic defences and be ready to argue those defences in appropriate circumstances. Also, in the material, you'll see some commentary about contempt and the execution of warrants. And very importantly, Part 8 deals with the issue of sentencing. And have a look at Section 9 of the Penalties and Sentences Act, Queensland, 1992, and that will provide the sentencing guidelines in relation to state-based criminal law litigation. So that's a very important section from a defence perspective. There are some examples of successful prosecutions in the magistrate's court, and bear in mind, of course, that the magistrate's court's jurisdictional limits only apply in civil proceedings. There is no maximum penalty that a magistrate can impose in relation to environmental litigation. So, for example, the case involving the former Lady Annie Mines decision, 2012 at Mount Isa Magistrates Court, the presiding magistrate imposed a fine of $500,000 and costs, in addition to that, of $83,000. So you can see a very substantial penalty imposed by a magistrate in those circumstances. And bear in mind, of course, from a regulatory perspective, that criminal law proceedings are generally regarded as the least cost-effective and impose the most modest of the fines, as opposed to, say, civil proceedings. So if you're comparing $500,000 fine to civil proceedings, civil proceedings must be enormous indeed. I mean, I don't think they would be anywhere near that, in fact, but just bear in mind as a general principle that regulators have the option of doing things other than proceeding in the criminal law sense when dealing with environmental offences. Dealing with environmental offences in the state regime, have a look at the Environmental Protection Act, have a look at Section 437, and 437(1) deals with willful and unlawful serious harm to the environment. 437(2) deals with unlawful serious environmental harm. And bear in mind, of course, that Section 24 of the Act provides that it does not limit any civil right or remedy as a result of pursuing criminal compensation. Now, that's at a state level. At a federal level, have a look at the EPBCA Section 495, and that deals with the issue of criminal liability of executive officers for the actions of the company involved. What I propose to do now is to put on share screen, and you should see on your screen now my screen showing the EPBCA Section 495 And in particular, you'll see subsection 2 provides that if a body corporate, which is a company, contravenes any one of a number of different important environmental-based provisions, then if you look at subsection B, if an executive officer was reckless as to whether the contravention would occur and was in a position to influence the conduct of the company and failed to take all reasonable steps to prevent the environmental harm, then the officer is guilty of an offence and may be prosecuted. You'll see down the bottom there a reference to the Crimes Act 1914. The Crimes Act is if you like, the criminal code in a Commonwealth sense. So as I showed you before, Section 9 of the Penalties and Sentences Act in Queensland outlines the factors for consideration in an environmental law, well, in a prosecution general sense. The Crimes Act 1914 similarly provides a number of provisions that are relevant to the process of sentencing. And in particular, I draw your attention to Section 16A, which deals with matters to which a court must have regard when passing sentence for federal offences. And you'll see that that has a very similar look to it, to Section 9 of the state-based legislation, the Penalties and Sentences Act. Okay, so that's a quick overview in relation to environmental criminal law litigation, and I'm just going to show you a couple of other things while we're on the share screen. And the first is in relation to the Legal Aid website. And you'll find the Legal Aid website is very valuable for a whole range of things. And it's been revamped recently. It's got a really nice, tidy look about it. And you'll see here under criminal court processes, some commentary in relation to matters in the Magistrates Court and matters in the District and Supreme Courts. And if you just poke around, have a look at some of those provisions, it's got some great information, including some information about, for example, sentencing in a more general sense, and so the process of committal hearings, types of committal hearings, etc. So, and bail. So I don't want to now make this a criminal law topic, but you'll find some valuable information in general terms on that Legal Aid website. If you also look at the National Judicial College of Australia, you'll find some terrific information in relation to the Commonwealth and sentencing database. So if I click on that, you'll see that the Commonwealth sentencing database has some wonderful information for use in dealing with Commonwealth-based litigation. So, for example, under Principles and Practice, you'll see some commentary in relation to sentencing methodology. If we go back, you'll see sentencing options, dealing with a number of different options that may be available in certain circumstances, and some information about publications as well. So it really is worth spending some time to look around that website, because it does have some very good information. So sentencing of federal offenders has information about federal sentencing generally. So you'll find a lot of good information there. In general sentencing principles, for example, there's some commentary there about Section 16 and the sentencing factors. And I'll leave you to read through that, but it's worth having a look at. All right, so I'll just stop the share screen now, and we might move on to topics of challenging environmental decision-making and ADR. This is commentary in relation to the week 11 notes that you have, and I'm sure you've read the notes already, but I'll just add to that. In terms of community litigants, often community litigants in environmental litigation have somewhat overlooked the role of community litigants in challenging environmental decision-making is clearly very important, and it's very encouraging when Parliament encourages the use of environmental litigation through the community as a legitimate means of dealing with environmental litigation generally. You might notice in your reading that in Victoria, many of the merits appeals decisions that are otherwise dealt with in the Planning and Environment Court in Queensland are dealt with by VCAT, the Victorian Civil and Administrative Tribunal, which is the counterpart of QCAT, where I'm a member, but it has extensive jurisdiction, and that includes Planning and Environment Court disputes, as opposed to the P&E Court that we have in Queensland. So in your reading, understand the importance of the difference between judicial review and merits reviews. We've talked about that through the course, particularly merits reviews, which are the matters primarily considered by the Planning and Environment Court in the context of making decisions about the issues of whether or not a particular matter should be approved or not. Now, judicial review is more legal in nature, and in a judicial review application, the administrative officer is to determine whether or not the decision-making process has been done properly. So judicial review, in essence, allows for accountability and transparency of decision-making process. And in essence, it's important because administrative decision-makers in environmental law are not legal experts, but they are required to take into account relevant matters, exclude irrelevant matters, and reach a conclusion that is reasonable based on the evidence presented. So in the event of applying for judicial review, it is possible to argue that the decision was not made in accordance with proper legal principles for a number of reasons, and they're set out in 2.3 of your notes. So, for example, the decision maker had no jurisdiction, or made an error of law, or exhibited bias, or exhibited bad faith, or failed to give appropriate weighting to the evidence. So these are the sorts of things that a court will consider in the context of judicial review. Now, one important one is ultra vires, which is essentially that the decision maker is acting outside power. So I said beyond power, the Latin term ultra vires, and there are some important decisions that relate to whether or not a particular decision maker had the power to embark upon that principle or that decision making. Okay, and the remedies that are available upon judicial review, these are in 2.5, I believe. The court may affirm the original decision, order the decision be quashed, return it back to the decision maker for reconsideration, etc. Now, merits reviews, that's in 3.0. You can think about all the main cases in the Planning and Environment Court. Well, they're primarily to do with merits review decisions, and you'll recall that is where the court steps into the shoes of the original decision maker to make the correct and preferable decision. And we see that in the QCAT jurisdiction as well. So that's the difference essentially between merits reviews and judicial review. Bear in mind there's also other procedures that may apply. For example, internal reviews. So have a look at section 521 of the EPA, for example, where in certain circumstances a dissatisfied person is required to seek an internal review of the decision before appealing to the Planning and Environment Court. So, and in that instance, a more senior departmental officer conducts and reviews the decision of the original decision maker and will consider the decision afresh. So it's like an internal merits review before you go to the Planning and Environment Court. And part of the reason, I guess, the policy behind this is to save time and money for not only the department but also the litigants themselves. Look, it might be appropriate for me just to have a look at some of the planning directions that apply in the P&E court jurisdiction. And part of this is segueing into the ADR issue. And I'll talk more formally about ADR, but for the moment, I'm just going to attempt to share the screen again. And you should see the last thing that we were talking about, which is the sentencing principles. I'll close that, close the Crimes Act, close the issue to do with legal aid, and we'll have a look at Practice Direction number 2 of 2014. So there is a link in your notes to this practice direction, and it's important that you understand this because the process of alternative dispute resolution is heavily involved in the process of determining matters in the Planning and Environment Court. And the practice direction sets out the procedures for the case management in a just and expeditious resolution of real issues in proceedings at a minimum of expense. So in practice, if you're involved in environmental litigation, you must be aware of these practice directions because it will have a direct and immediate impact on the way in which litigation is conducted. And you'll see there's an application for a directions order, and the application for an order or for a direction, and this is rule number 4 or direction number 4, about the future conduct of the proceedings must be brought as soon as practicable, but in any event, have a look at this, within 6 weeks after instituting proceedings. And that's by reason of section 446, subsection 2 of the Act. So what that means is that if you are acting for a party in initiating proceedings in the Planning and Environment Court, you must be aware of your obligation to immediately, or at least within 6 weeks, make an application for orders or directions about the conduct of the matter. So in other words, the P&E Court is designed to make the litigation move quickly. It's not a case of filing the material and then sitting on it for a year. You've got 6 weeks to get cracking. So really you should have this application for the directions order and understand what you want even before you file the original material. So then the direction goes on to talk about affidavits, the content of the directions order, and I'll leave you to read that at your leisure. But you will see that very quickly, the parties are referred to the ADR registrar, and the ADR registrar then may list the matter for review and essentially takes an active role in the management of this litigation through the ADR process prior to it getting to the P&E Court. So presumably all the cases that you read about in relation to merits reviews in the P&E Court have been through this ADR process, and through that process the parties have hopefully made a genuine attempt to resolve the matter. And that was signed by the former Chief Judge, Judge Wolf. All right, so that's one of the practice directions that I wish to refer you to. The second is practice direction number 12 of 2013, and this practice direction deals with the way in which parties are required to cite case law in any matters before the Planning and Environment Court. So just be aware of that and don't fall into the trap of making a mistake as to how to cite your material. And finally, Practice Direction 1 of 2011 ensures the proceedings that relate to infrastructure charges or conditions on a development approval proceed to ADR at an early stage, preferably without the need for an order or direction by a judge. Okay, so that's the ADR aspects from a practice direction perspective of the Planning and Environment Court litigation. Now, are there any questions at this stage? I know I'm moving quickly to some degree. Yes.
Oh, it's just a general thing about those practice directions. How do they come about?
Essentially, the Chief Judge in this case will make those practice directions from time to time. And you'll see that the first one I showed you, which was practice direction number 2 of 2014, that actually replaced a practice direction number 2 of 2011. They do change from time to time.
Yeah, okay.
All right, thanks, Tony. So it's really important in litigation not just to think about the form or the Act, but also think about planning directions and the regulations of the court. Now, I should just say as a general rule, If there is a regulation that's specific to a court, that will override the more general regulations or rules. So in that context, because the P&E court has its own rules, have a look at the P&E court rules, which will essentially override the Uniform Civil Procedure rules in the event of inconsistency. But if there's a gap in the P&E rules, then look to the UCPR. Gosh, I hope that makes sense. I'm moving quickly, but I think you've got it. I think you've got the idea. All right. Thank you. See, week 11 notes, 7.0. Thank you. Okay, so we've talked about ADR in the context of planning and environment court litigation. Have a look at your notes and you'll see that the ADR registrar does have determinative powers, and that's section 491B of the Sustainable Planning Act. And then there is practice direction number 8 of 2014. That's reproduced in the material. I haven't shown you that tonight, but you'll see that it followed the decision of His Honour Horniman Wren SC in Western Brisbane City Council. Judge Horniman Wren was, until recently, the Deputy President at QCAT. Right, so we've got the Land Court practice directions as well, and then you've got the State Development Public Works Organisation Act as well. Some commentary in there. Okay, so what I want to do now is just follow through on that theme of ADR in a little more detail, but before I do, I'm just going to just go back to one of the problems in the weekly problems. This is from week 11, and that is problem number 25. So if you've got Moodle up, if you want to have a look at problem 25, and it deals with the issue of environmental enforcement of environmental laws and challenging environmental decision making. So if you've got any ideas on this, please let me know. But in essence, the question is, environmental law would be so much more respected if merits appeals were abolished. Public service didn't have to look over their shoulder when making a decision, thinking that someone is going to sneak up on them and brandish an application for judicial review or merits review. So maybe regulators could then get on the task without the annoying time-wasting challenges. Are there any thoughts about that particular question? Are there any issues that it raises in your mind? So use the chat facility or unmute if you wish.
No, I just think it's a good idea to get rid of the merits appeal. Anything to get rid of anything out of those tribunals is good.
Yep, no, that's fair enough, Tony.
I just say that because, you know, a few times I've asked a few things, you know, you say you go through the process and they just try and find ways, they don't like being wrong and admitting that, you know, so, and it's just a waste of time, I think. So where if you got rid of it and it went to a court or something, you'd get a proper result straight away.
Mm-hmm. Yep, yeah. No, that's fine. Mind you, a merits appeal in the P&E context means that the matter is then taken from the decision maker to the Planning and Environment Court. So in that sense, it does achieve that. There are the exceptions where there are internal review processes that we talked about earlier tonight. But no, thank you for that. Any other comments? All right. So I've just made some notes here. Some of the things that you might want to consider in answering that question is, so while there are legal challenges through judicial review and challenges to the merits of the decision by merits review, both favour applicants for licences and proponents of project over objectors, perhaps. But when it comes to the rights of a merits review for an objector, it's really quite limited. And I guess you've got to ask yourself some of the questions. Is that appropriate? Should objectors have more right to challenge the decision making? Should they have less right? Do the current approaches maintain a satisfactory working balance between the ideals of transparency and accountability? Or do these opportunities unnecessarily increase workloads, uncertainty, expense associated with projects? So I'm not really providing answers, but just giving you thoughts about what you might consider. And are courts hearing judicial review tempted to overstep and start to engage in a merits review? Maybe that's a problem as well. So these are really some of the issues that you might want to raise in answering that sort of question. If there are any questions arising from those comments, and I know it's been pretty brief, please let me know. Otherwise, I'll move on to the next topic that I want to discuss, and that is in relation to ADR processes. So we have talked about a number of different criminal law processes tonight and also some ADR processes. But I just want to run you through something that I'm actually presenting tomorrow. So in a sense, it's a sneak peek. And I'm going to share the screen again. So tomorrow I'm presenting for the Queensland Law Society in a CPD intensive. My topic is Applied Skills in Mediation and Conciliation. One of the subjects that I take here as course coordinator is ADR, and what I'll be talking about tomorrow is, in the context of mediation, sort of some of the practical tips that may assist a party in dealing with the ADR process, mediation and conciliation. And I'm just moving through this pretty quickly. So when it comes to ADR, there's a number of options that are available to a client, and it's not just mediation or conciliation. Now, bear in mind, in an environmental law context, we are really talking about the ADR procedures as prescribed in the Act, whether we're talking land court or planning and environment court. But generally, there are a number of different options. So mediation is where the parties are assisted, but the mediator does not advise or determine the matter. Conciliation is what we call mediation with muscles, to quote Judge King of QCAT. And conciliation is where it's similar to mediation, but the conciliator can give advice, or if empowered to do so, make directions, but not determine the matter. So a conciliator in many contexts is able to actually make directions order. So when you read through the practice directions for the Planning and Environment Court, you might like to ask yourself whether the ADR registrar is exhibiting powers typical of a mediator or more of a conciliator. And I think probably it's fair to say it's more of a conciliator. But in general terms, you need to consider there are a number of options, and I won't go through them now, but the mediation and conciliation, they're pretty much in the middle range. So the most determinative interventionist model is arbitration, and that is essentially somewhat similar to court proceedings. So there are a number of different options, but one of the things you need to consider is, in the ADR context, is litigation the most suitable method of dispute resolution, or can it be resolved through ADR? As you know, through the P&E court, land court, it will be referred to ADR anyway, but it may be something that if you're involved in acting for a party, potentially or real, then you should consider and discuss the ADR options right at the start. As I said, the matter will be subject to ADR proceedings and directions orders within 6 weeks of initiating the proceedings, so you've got to think about it at the start. In terms of ADR, if you are advising a party in that context, I guess your demeanour, your attitude will influence the attitude and behaviour of your client. If you dismiss ADR as an option, we're probably not going to get very far. But if you enthusiastically embrace it, then so too may your client. And remember, of course, that you need to consider obtaining written instructions from a client throughout the process. You've still got your ethical obligations to consider, and your overriding objective is to the administration of justice. So if you refuse to consider ADR as an option, then you've got to ask yourself, am I truly fulfilling my duty to the client, but more importantly to the administration of justice and the courts? So sometimes you are required to consider ADR before you proceed to litigation, and you've got to think about how to approach ADR. So if you're dealing with a planning and environment court dispute matter, and you know that you need to go to the ADR process, then maybe you should think as would be the case for the ADR registrar. Think about what the ADR registrar is going to do, and that means thinking about the wider issues, not just necessarily the legal issues, and come up with a plan that best provides for resolution of the matter for your client. That may involve actually running a mock presentation of your case and really doing some genuine reality testing. By reality testing, I really mean testing the what if. What if you proceed with this litigation? What if you don't? Where are we going with this? And you need to understand the process of ADR proceedings. If you're representing a client in ADR, bear in mind that it's really up to your client to retain ownership of the dispute. And in ADR, lawyers are not necessarily going to be the main participant, and probably shouldn't be the main participant. In ADR, it should really be your client. So the mediator will try to keep the matters going, remain light on their feet, and use a number of different ways, such as rephrasing, summarising, or reframing rather, and reality testing in order to come to a resolution. So in understanding the process, it's pretty simple. The mediators make a statement, the parties make a statement, the mediator will assist the parties in setting an agenda. There'll be an open session between all the parties, and then the mediator may go into a private session, and if that doesn't work, another joint session, and hopefully there'll be a resolution. So bear in mind that part of the role of the mediator in the ADR sessions is to try to come up with ways of enabling parties to look at things from others' perspectives. So there's the parable of the blind men and the elephant, who from their own perspective come up with different versions of what they are encountering. You know, what they see is it's rope or a wall or tree or a fan or a spear or a snake, depending on their own perspective. So and for dealing with that sort of creature in a mediation session, there's a few different ways. Stay calm, don't react abruptly, use reframing. And in terms of the ADR process, you need to ensure that you understand the process, that your client has authority to settle. Think about your evidence. Have you got everything that you need before you start? And come up with a draft outline of your client's position and interests, and a statement of facts of legal issues as well. And I'll just move pretty quickly through the rest of it. So the number of questions that you need to ask your client before you go into the ADR process. What are the legal fees? What are the likely further legal fees? What are the prospects of making a costs order? If the matter doesn't settle, what are the opportunity costs for your clients? And just remember that your client will need to consider a few things, and one of them generally in environmental litigation will be the effect on health and stress, time and money. Now it's not so bad for the institutional developer in an application for a coal mine, may be prepared to throw millions of dollars at this. But different if you're acting for a community litigant having to face that. So there are a few things that community litigants in particular might want to consider. And I'm saying this in the context of ADR processes. So in preparing for the ADR, you might actually prepare a checklist like that. So you're not dealing with just the legal issues, but you're dealing with the wider issues. What are the issues for your client? What are the issues for the other side? What does your client want? Maybe brainstorm some of the things that may lead to a resolution, and think about what are the issues if the matter does not settle. What are the costs, in other words? So that's something that you could do in preparation for an ADR session. And in actually participating, just be aware the ADR practitioner will ask certain questions. Why hasn't it settled? And the ADR practitioner will have a number of different techniques to try and resolve the issue. And one of them is reframing, that's detoxifying. So what you're trying to do is strip the emotive content from the statement. You know, he's always leaving things lying around. So your response is, so you have concerns about his lifestyle and you want him to know how his actions impact on you. So these are general ADR principles. I won't go through those in any further detail. Look, there is one thing that you might want to do in genealogy. A genogram represents family relationships through the use of symbols. So, and it's just a general thing. If you get a convoluted type arrangement of different people and trying to understand the interaction between the parties, then maybe come up with a genogram of your own. I do that regularly when I've got clients that want to tell me about different parts of the family and disputes and who's good, who's bad, who's difficult to deal with. So that type of thing, and that's from Love Actually, shows the interrelationship of the parties. So a genogram might be useful in those issues. All right, so thank you for that opportunity to a quick run through of what I'm going to do tomorrow. I'll stop the share now. So are there any questions about what we've covered tonight? You've been very patient. Are there any issues? All right. Well, next week it will just purely be a matter of dealing with the examination, and I'll run through some of the exam questions. If you have any questions about that, please ask through UCrew. I expect to have the results of the second assessment piece available. Let's see. Yeah, that second assessment piece should be available on Sunday. So that's already where we're up to. Okay, are there any questions? Yeah, sorry, Tony.
Oh, no, I was just going to say, you got a time on Sunday?
Oh, no, probably early.
Oh, okay.
Okay, but probably early. But I'll make a note to myself. All right, and I'll announce it. I'll say that the results are now released. Okay. All right, well, thanks for your attendance tonight. I'll stop the recording and all the best.